Nick Maruchek joins us from MKI Legal. G'day, Nick.
G'day, Bowie.
Just seen the Commissioner wander out.
Yes.
It's a reasonably involved job, that one, isn't it?
It's a tough job, yeah. I wouldn't want to do that. It's a lot of people to manage and a lot of stakeholders involved, everyone giving an opinion. I wouldn't want to be in his shoes.
We, I guess, pressed him a little bit on, there's 1,880 kids who behave badly that are known to police, have been before the police and before the courts a number of times. In all of that, there's magistrates and judges, district court judges, children's court judges as well, magistrates. I asked you the question ages ago that should they have performance reviews? The magistrates. Do you know any judges and magistrates? Do you feel? And I know a couple, former and current. Are they real people who exist in the real world?
So with the magistrates, a lot of them, like I've got a friend who's on track to be a magistrate, right? And we think in 10 years' time he's going to get there. He's worked in the criminal justice system for a long time. He's in legal aid now, so he's done so many cases. So someone like him who's had real life experience defending people and doing all that legal aid work, great. They're in a really great position. But then sometimes you get the judges who are, from the barrister class, who are the elitists, the QCs, the ones that rub shoulders with the wealthy and stuff, and and they've got the networks and they're appointed to the high positions. Sometimes maybe they're out of touch. So it all depends. But
depends on the individual, right?
Yeah. Mm-hmm. But I like to think that our system is quite good, and it's all. I'd like to think it's all based on merit. But in terms of performance reviews for judges, it's a hard thing to do because each judge will be managed by the chief judge of that court, and judges are supposed to be impartial. They're supposed to be independent. So the performance review thing it doesn't really happen in practice. You can make a complaint about a judge, and it's really hard to remove them as well because most of the time you need to remove a judge, you need to go through Parliament. So yeah, I haven't seen many cases of judges being removed at all. So.
All right. Thank you for your thoughts. 133 882. If you'd like to call in today, if you'd like to ask Nick a question, you can. Irene, thank you for calling. How are you today?
I'm very well, thank you, Simon. How are you both?
Yeah, going well. How can Nick help?
Nick, I've got a question about power of attorney. My husband and I did one in 2007, and we've recently been looking it over with our financial advisor, and she's noted that we've signed on the wrong line. We should have signed on clause 1, and we've signed on clause 1A, and it should be appointed substitute attorneys that signed. We've done it the opposite way round. And I just wondered, would this matter at all, or does it render it invalid?
It would be a good idea to re-sign it, because what is the actual error you've made? Did you appoint the wrong people as your attorneys?
No, we just signed on the wrong line. We signed where they should have, and they signed where we should have. The appointed attorney, which is like my husband for me and him for, me for him, and then our children in joint next. So they've signed where we should have signed, and we've signed where they should have signed.
All right.
Well, look, generally speaking, I think that would hold up, right? Because for an enduring power of attorney, you basically have to use a prescribed form. You have to sign it in front of 2 witnesses. So as long as you've actually signed the form, your signature's on the page, yes, there's a good chance that would hold up. But out of completeness, if you're able to redo it and re-sign it properly, that's what I would recommend. But in my view, there is a really good chance that it'll hold up, because if you followed all the correct procedures and you simply just signed in the wrong spot, you've still signed the document, because for it to be valid, it just says you have to sign it. The law doesn't say you have to sign in the wrong place, in a specific place. And also, this is a form over substance kind of issue. Like you've done, this is a style over substance issue. And the substance is there, so I think it will hold up. But if you're able to, and enduring powers of attorney are really simple to prepare. You can download them from government websites, and you can just re-sign it in front of 2 witnesses.
What's your advice, Irene? Are you being told to re-sign it, or?
No, she thought it would hold up, like Nick said.
Yeah.
But she said, but you should really check it with a lawyer, because she's a financial advisor, and she's quite familiar. But she said the signatures are there, so there's not a problem.
Yeah, gotcha. So Nick's advice is it should hold up.
Yes.
So that's radio legal advice.
That's
but it might be
that's not legal advice.
Nah,
it's general information.
Yeah,
because I don't know the full. I haven't seen the document.
Yeah, try officially approaching a lawyer. But good advice from you, Nick. Thanks, Irene. Thanks very much for your call. That's an interesting one. Signing on the wrong line. I do that all the time because I've got poor eyesight, Nick.
So 9 times out of 10 will be fine. But if you got an opportunity to change it, just download a jury power of attorney template from government website, re-sign it, and then it's 100% no doubt there at all. Yeah,
if you'd like to speak to Nick Maruchak, you can. 133 882 is the phone number. Just on, we are aware of an anonymous email that came into, or a confidential email that came into our breakfast show on elder abuse. And elder abuse takes many forms. Tell us about this one.
So this was sent to the Brekkie crew a few weeks back, and I've got it in my lap. And it's basically a situation where a elderly father in Perth with advanced Alzheimer's is allegedly being financially exploited by his son. His son's got an enduring power of attorney, and the brother, so the other son, emailed through. And some of the things that this son who's got the power of attorney has done, he's stated that he plans to sell the father's house. He plans to use half of the proceeds to fund his own property. He's even taken steps to cancel the father's insurance without informing everyone else. So this very much looks like and smells like elder abuse. 1 in 6 older Australians experience some form of elder abuse every year. And the Age Discrimination Commissioner actually thinks that this is actually going to increase because of the economic pressure, the housing stress, the cost of living stress. This, people would use that to justify elder abuse, so you have to be really careful about this. So, when you're appointed as a power of attorney, there's duties you have under the Guardianship and Administration Act. The 2 main ones are when you're an attorney, you're acting in a role, you have to act in the best interests of the person who appointed you, not for your own interests. That's rule number 1. Rule number 2, as an attorney, you have to keep accurate records and accounts. So they're the 2 things that cover the son, and obviously he doesn't seem to be acting in the best interest of the father here. So what can be done? Well, you can go to the State Administrative Tribunal. Any interested party, so any other family member or anyone who's got an interest in the father's affairs, can go to the State Administrative Tribunal and basically ask for the attorney to be investigated in a way. So under Section 109 of this Act, you can ask to produce all records, so you can open up the books. The State Administrative Tribunal can even appoint an independent auditor. And once you look through all of that, if there is abuse, it would come to light. And especially if the attorney hasn't kept accurate records. So then they can have powers to cancel that enduring power of attorney, appoint someone else. As a last resort, they can appoint the public trustee. And if there's any kind of imminent threat of assets being sold or dissipated, they can probably make a temporary order to freeze everything to stop further loss. And the final thing is just, if you're concerned, there is resources out there. So the Office of the Public Advocate has a great telephone line you can call, and Advocare has also WA Elder Abuse Helpline as well. So so there's some stuff. And so
all right. Thanks, Nick.
Yeah.
Thanks for looking into it for us. Hi, Mark. How are you?
Yeah, good, thanks, guys. Just quickly, I'm doing some new wills and powers of attorney. Am I forced to leave the originals with the lawyer? Is there some sort of law? Because I've had it in the past where they say, no, we have to keep them and then I have to pay to go and see them. Is that the case?
No. So you don't, definitely not. And the lawyer, if they tell you have to store it with them, then they're not being upfront with you. They're being slightly misleading. So you need the original copy of the will when you pass away. So it has to be stored in a safe place. So you can leave it with a lawyer if you want, but you don't have to. There is other services out there. There is a service called the Wills Bank, which is run by the public trustee. You can store your will there, or you can just store it at your own house in, say, in a cabinet or in a filing cabinet, safe. Tell the executor where it is, and when you pass away, they can get a locksmith to open it up and stuff like that. So definitely, you don't have to. And the public trustee will storage is a good place to have a look at. I'll just be careful. Sometimes they give you that free storage if you do your will with a public trustee if you appoint the public trustee as your executor. But just be careful of that, because the public trustee does take a chunk of the estate, or they do charge. Some people aren't happy with their charging fee arrangements.
So Mark and you were talking about the physical copy, hey? The actual paper, A4 copy.
You need the physical signed copy with the actual signatures.
Yep.
That's what you need to supply to the probate office when you pass away. So you have to store that in a safe place. Your executors have to know where to find it, because if you don't have that and you've only got a photocopy, it's going to make the process harder. You can actually get probate with a copy, but you have to jump through hoops. You have to go through a different process.
Yeah. Does that help, Mark?
Yeah, it just helps because I have a current will. I wanted to go and see it to change it. They're going to charge me more to see them to change it than it was for me to go to another law firm and get a whole new set made up. So,
Wow. Well,
Yeah.
wow, that's amazing.
So you should probably just ask them to return the will to you when you create your new will. Rip up the old one so there's no confusion. So
But Mark's saying, is there a fee for that, Mark, even having it returned?
they wanted to charge me time to present it to me and advise me on that and suggest things, and it was all time and money. So I just said, well, keep it. I'll go and do a new will somewhere else. So
Yeah. And I mean, you can just ask for your will back without any legal assistance. Just go, I just want the will sent to me and I don't want any advice. So don't charge me for any legal services. Just give me my document back.
Mark,
ask for that.
Can you try that, Mark, and let us know how you go, mate, if that's all right?
Yeah.
Can you try just...
well, I did ask for that in an email, and they said, no, they have to meet them. It's their policy.
Oh,
So,
Well, I can have a look into that because that doesn't smell right to me. I think that if
it's not advice, eh?
yeah,
So
they're
just-
forcing you to use their services, which doesn't sound right to me. It's if they're storing the will, and then if you want it back, they should give it back to you.
Yeah.
Because
I would have thought
yeah.
so. Yeah, Mark, that's very interesting. There'll be a lot of people in the same boat as you. Mark, I'm going to put you back to Kira and to Sophie, and Nick will have a look at that one for you. Cheers, mate. Very interesting topic. Thank you. It is 13 minutes to 11. I'm Simon Beaumont. This is Law Talk with Nick Maruchak. Mick Collis is not far away, so he'll be in after 11 o'clock today. The beautiful mind of Mick Collis. Is your house worth $1 million? The yeses are 33 and the noes are 4. Domain are saying that by the end of the year, by Christmas, the median house price in Perth will be $1 million. That's incredible, isn't it? Carl's phoned in. Hi, Carl.
Hi, guys. I had some court orders made through the family court, and we were listed to go to trial to sort out our financial matters, but then we cancelled going to trial. I want to know if previous court orders that were made in regards to children and other matters still stand.
So this is a financial case you're involved in, and in the past there was court orders about children, right? So different topic. Is that a different topic to the trial that's going ahead?
Yes, correct.
Okay, so the court orders that were they made by consent or were made through a trial?
No, by consent.
Okay, for the children? So they would still
For
stand?
the children and for the home, yes.
Okay, so court orders will stand unless they are revoked, right? So
Okay.
So there's a good chance that they will stand, yes. I just need a
fine.
bit more details.
Fantastic.
Yeah, because...
yeah, no, that's okay. I was wondering, because we cancelled going to trial, I was wondering if they cancelled all previous things as well.
Yeah, because if you made those court orders in the past, for an order to be cancelled, you really need other orders to say those previous orders have been set aside, right? So if you go into trial, maybe if you had court orders to say you have to file these court papers within a certain date and then the trial gets cancelled, maybe those won't apply. But certainly the orders about the children and any other like matters about property division would stand until they're revoked. So so that's what that's kind of the information that I have at the moment. But I would definitely check it out. I can have a chat to you further if you like, just to have a look at those orders and confirm if anything stands out. If you leave your details and send them to me if you like.
Put you back to Sophie and to Kira. Carl, thank you, mate. Thanks for calling in. One of our correspondents on the text terminal, Nick, says, this is Glenn with 2 N's. I dropped my original will at the Will Bank in Perth. Is there any fees we need to retrieve the will? This is what we were talking about before, wasn't it? What's the proper name of the Will Bank?
Well, the public trustee runs it, right? So I call it the Will Bank. So if you just Google Will Bank and public trustee, it's a service that they run in Perth. It's on their government website. And I am not sure at the moment of the fees off the top of my head, but my understanding is their fees are relatively competitive. And and not overly expensive. Just the thing to be careful about with a public trustee is they have this will bank service, which is great service, but then what they do is they try and offer you a will, and they want to prepare a will for you, and they want the public trustee to be the executor. So that means when you pass away, the public trustee will take over to manage all your estate, and they will take a fee for that.
Okay.
So many people are, over time, in the past, their fees used to be a percentage of the estate. It used to be quite exorbitant. I know when I was practicing in this area, people used to be very critical of the fees the public trustee charges. Over time, they've kind of changed their fees to not take based on percentage, but you're still going to pay something to them. So if you can appoint a friend or a family member or a child to act as executor instead of the public trustee, then you're not going to lose that in legal fees.
Wow. So I would imagine this is an area of state government, isn't it, Nick?
Yeah.
Who's the minister for the public trustee? Would you know? Is it the finance minister or the treasurer? Who would look after that? I mean, question without notice. You, by all means, let us know in ensuing weeks. But that's very interesting. Will storage is an interesting topic, isn't it?
Yeah.
We all need to do it.
That's right. So the public trustee has been around for a long time. I don't know the minister off the top of my head because that's a great question. But my guess, it would be it would fall under the Department of Justice, right?
Okay,
so that's where the minister for that area would be
the Attorney General.
Yeah.
Yeah. Okay.
Yep.
All right.
So that's my best guess.
Yeah. Thank you. We'll confirm that. Thanks, Glenn. Thanks for your correspondence today. 4.5 minutes to 11 o'clock. We had just quickly, Nick, we got a couple of minutes remaining. We had an Uber driver issue too, didn't we? From memory.
Yep. This is just a great case that happened a while back. So we have new laws passed that protects Uber drivers, because in the past they were contractors, so that if they were terminated by Uber, there was nothing they can do. So we had these new laws passed, which anyone who works on a digital labour platform who gets deactivated, and if they've been working on that platform for more than 6 months, they have rights, basically the same as an employee does. So in this case, there was an Uber driver. His name was Mr. Hotek, and he had passengers that were using drugs in his car. He told them to leave. Then they assaulted him, and then they made a fake complaint that these drug users, said that this Uber driver was threatening them. So Uber deactivated him, and then he lodged a complaint to the Fair Work. And he won, and the main reason he won was because, for two reasons. One is Uber, there is this digital labour platform deactivation code that Uber has to follow, and they didn't follow it. One of the key provisions of the code is if an Uber driver requests a review, you have to have a human available to provide and to speak with them. Uber didn't do that. And the second thing is, when it came to actually have an argument about what was the circumstance of the case, did these people use drugs, was he threatened? Uber didn't have any evidence, right? So the only evidence that the court had, the commission had, was Mr. Hotek's evidence, and they believed him. So the lesson here is that if Uber makes an allegation against you to deactivate you, they also have to prove that you did it, and that's going to be hard at times. So he won, and he basically got some money for the lost income, and then he got reinstated.
Yeah. Was that here in WA or
that was an Eastern States one?
Yeah,
but
okay.
the same laws apply. It's national laws across the country.
Yeah.
So this was it was a good win, and now these tech companies have to, they can't just be the, can't make decisions so quickly.
Yeah,
and
it does happen quite a bit, doesn't it? Thank you very much, Nick. I really enjoyed today's chat, and we'll try and find out a little bit more about the will storage for our listeners. And thanks for following up on a couple of things there with Irene and Carl. Appreciate it.
Thank you.
Thanks, Nick. Have a good day, mate. See you, Nick Maruchak from MKI Legal. We'll take a break. When we come back, the 11 o'clock news with Philippa.